For joining us on another episode of The Legal Edge. Justice is said to be the foundation of peace and fairness in any society. But in Nigeria today, how many people can truly say they have access to justice when they need it most? On today's episode, we are digging into the real challenges behind access to justice in Nigeria, and more importantly, how we can begin to fix them. And to discuss these issues, we have in the studio a professor of jurisprudence, a senior advocate of Nigeria, and chair of the Nigerian Bar Association Institute of Continuing Legal Education, Professor Festus Emiri. Welcome, sir. Good morning.
Good morning.
Thank you for joining us on the show this morning, sir.
Thank you, madam.
So, yes, thank you for joining us this morning. Remember, you can join the conversation by calling us on 0912 000 1975. That is 0912 000 1975. We'll be back shortly to discuss the case of Chinedu, the apprentice. Stay with us. Thank you for staying tuned with us. Access to justice in Nigeria, challenges and the way forward is our topic this morning. And we have in the studio Professor Festus Emiri, SAN, to discuss this topic with us. Straight to our story for this morning. Chinedu, a 25-year-old from a rural village in Enugu State, left home to serve as an apprentice in a popular electronics shop in Port Harcourt. After 7 years of loyal service, his boss promised to settle him as is tradition. But when the time came, the boss gave him 5 million naira instead of 10 million as agreed at the start of the apprenticeship. Upon complaint about the amount, his boss threatened to lock him up for life. True to his oga's words, Chinedu was arrested the next day based on the reports of theft lodged with the police. At the police station, he was detained without being charged for over 2 weeks. He didn't know his rights. No one told him he had the right to a lawyer or to be charged within 48 hours. He had to use the settlement money to hire a young lawyer. He was eventually acquitted and released as there was no evidence of theft, but this was after 5 years of trial. His lawyer has now helped him file a civil suit for compensation and breach of his apprenticeship agreement. But Chinedu feels disillusioned as he has spent all his money and 5 years of his life defending himself for a crime he did not commit. Sir, that's our story this morning. A lot to unpack here, sir.
Very well.
Yes. Can you help us look at the few legal issues in the story, sir?
Well, by my count, there are several legal issues that arise. One, we look at the substance of the rights he's pursuing. We also look at the question of taking rights seriously and whether the justice system actually can deliver personal contextual justice. Because the problem we have is you can have what we call justice, which is pyrrhic. Pyrrhic in the sense that, yes, after 5 years, he's declared innocent. Yes, but even at that, that's not exactly what the man is looking at. The man would have been happy if his matter was listened to and decided within the shortest period of time. He would also have been happy if the police would investigate first before detaining him, because those are issues that normally when people just make a complaint, all the police do, rather than investigate, they immediately arrest and the man becomes a suspect. That's not how it should be. If we are looking at proper access to justice, then of course you've heard one story. So listen to the other side. So the only way you can listen to the other side is to do an investigation. But what we have in our society is that the police immediately arrest, and once they arrest, they detain the person. The person is kept there. He has to put his hand in his pocket, and if he's unfortunate fortunate to be a person who is not of deep pocket, then of course he will spend his time there, just like Chinedu has done, happened to Chinedu. Now, even when the fellow eventually gets out of the whole problem and is declared innocent by a court, he now wants to seek a remedy. The question is there substantive remedy that would satisfy him? One, he would need to look at contracts. Was there a contract between him and his master? How does he prove those elements of a contract? Was the contract in writing? Most likely, contracts like that are not in writing. And the reason is very obvious, because when a man is happy, of course, usually, you just said he's a young man from a very rural community in Enugu. He's coming to the urban city, coming to a metropolis. So the man is happy to say, look, I'm just going there. Even when you talk about an agreement, the man just says, I'm just here. Let me learn the work. I know that at the end of 7 years, I'm going to be looking at 10 million.
Yes.
So we need to look at how oral contracts themselves can be enforced. And then, of course, the fact that it's an oral contract does not mean it's not a contract, because a contract can be in writing, it can also be oral. So he has to be able to prove how the elements of the contract and intention to create legal relationship and several other things like that. Even at that, he will be thinking of bringing like an action for malicious prosecution, that he was prosecuted wrongly, and the master, of course, knew that he was maliciously prosecuting. But then you have to look at those ingredients to raise that kind of claim in court, which is a tortious claim. He has to show that the arrest was unjustified, and then that there was no basis for it. But all the man would tell you, the other man would have a defense. And the defense is that, look, I just laid a complaint to the police, and it was a police action. So the police did what they are supposed to do. So you see that it becomes very difficult even also to succeed in a suit for malicious prosecution in torts. So these are some of the issues that have to do with the substance of rights. So those are the problems Chinedu will run into. But then I've always said that lawyers also can help in this situation. We don't have lawyers tell stories. They don't know how to tell stories, because telling a story can just be all that is required. I give you an example. I did some work for a university where I teach legal writing in Kwame Nkrumah University. And I gave my students just a simple question like, here they are. A man is invited into a place to deliver a lecture, and he fell, and he now sued the owners of the hotel for injury to himself. And I asked my students to just draw up what we call like a statement of facts, what we call in Nigeria a statement of claim. Now, all they just did is, this is a hotel situated in Yenegua, and this is the plaintiff, and they just did something which is so dry and uninteresting. And I asked them quite a few questions that, look, for every tortious claim, there's a need to give particulars, and those particulars are the things the judges are looking for. So lawyers need to learn how to write a story. And I asked them a question. The man who went to deliver a lecture, how old is he? They say he's 56 years old. I say, does that matter to you? And they say, yes, it matters. I say, well, so why is it not in the statement of facts? State that the man is 56 years old. That creates what I call a pathos. So the judges now begin to see that he's not even a young man. He's an elderly person who is invited to a place. So if he breaks his feet, of course, it will take a longer time for him to get healed. Then I asked them another question. What kind of shoe was the man wearing? Is it there in the statement of facts? They say, no, it's not there. I said, does it not matter? If the man is wearing a flat shoe that has grips, does it not matter? They say it does matter. It really shows that the man exactly was walking properly and that his shoes were good. So put it in the statement of facts. I asked them another question. I said, outside that, did you describe the hall? They said, no. Why is it not? It is important. So the judge can begin to see, feel, taste, and see how the place is organized. And I went on further to ask them, outside that, did you put in that statement of fact how many persons were in that hall when the man fell? They said no. I said, does it matter? How many persons were there? They said 500. I said, if a man falls in the presence of 500 persons, does it not sound very embarrassing? They say it does. I said, so put it there. So when you add up all of this, so lawyers need to also learn how to write, to tell stories like novelists. You see, when you pick a novel, you read it it's interesting. But you take a legal document and you are reading, it's just there, stilted. So these are some of the things lawyers can also do to help give people better access to justice. They learn how to write. Lawyers need to learn how to write too.
Okay, thank you, sir. We'll still go back to the role that lawyers and other persons in society can play in creating more access to justice. But for now, when you look at the statement access to justice, what do you think it's what does it really mean contextually, in a Nigerian context when you say access to justice?
Well, access to justice has two areas I would like to look at: the procedural aspect and the substantive aspect. The procedural aspect is what are the procedures, what are the things you need to do to get to justice? And then the substance is when you now get there, do you get really what you want? I give you an example of substantial justice. Here is a man who worked for a man. In an article I wrote many years ago, somewhere in Ogun State, and having worked for the man refused to pay him his money. So what he does one day, he hears the man is in town, so he goes to his house, and he makes a lot of noise at the gate that the door be opened, and the man won't open the door because the big man is inside. And the big man gets the police to arrest the poor man who he has not paid, and then the police charge him for conduct likely to cause breach of peace. So here the man is in court, and he's telling the judge asks him, are you guilty or not guilty? And the man would say in Yoruba language, that is, I'm guilty with reason. So the man is saying, look, I am guilty, yes, if you say I made noise and caused, but I have a reason for it. And he says, what is your reason? The man says, I'm being owed money. But that's not a defense to the charge. The defense to the charge is that he did not cause trouble there. But he did cause trouble, make noise. So the man is telling his lawyer that I have a right. I think what I did is right. But the law says that right cannot be vindicated in court. So the man is liable for the offense, even though the big man is owing him money. So these are the substantive things we talk about rights. The rights sometimes don't meet what you call justice. Like the story of a woman who had a goat who said, look, the goat was stolen from her. That's the goat that the woman uses to get milk and do several things. And then the thief is arrested and the thief is in a police station, and you ask the woman to come to the station. The woman goes there. From there, the matter is charged to court. She goes to court 1, 2, 3, 4, 5, 6 times, and she said, look, I'm just tired. And they said, don't worry, madam, the case will soon be decided. The woman says, look, why don't you just give me my goats? That's all I want. I don't want case. So you see that rights, the procedures even in law are not just there. That is why it is sad to say that in Nigeria, only 28% of Nigerians trust the courts. In fact, remember what Henry VI will say. He says, one of the first things we do, let's kill all the lawyers, because there's no justice in the world.
So, wow, that's a big gloom, especially for lawyers. Okay. Can we look at what the biggest barriers are to access to justice?
Well, we talk about big barriers. I look at small barriers. Let me talk about small barriers. You see, we are used to doing so many big things. Oh, we create new rules of court. We create new rules for criminal procedure. Those are not the big things. The big things are the enforcement. Doing the small things. It has to do with first our attitude. Are those who are the hem of affairs in the legal profession, are they really serious? Are they interested in the small things? They're looking at making new rules. These new rules are just there. The man on the street doesn't feel the rules. The man on the street will be happy if the police would arrest him and the police would investigate. And not that he has to be arrested and he has to put in detention and you ask for bail. So let's start with the small things. Everyday crimes are committed. Nobody's talking about crimes. Let's start with the small things. When a policeman is holding a gun and is at a checkpoint and people are giving him money, do you know what the policeman is doing? He's committing robbery. So there are so many robberies every day in Nigeria not prosecuted. These are the small things we should address. Because what is robbery? A man who forces you to give money. And here is a man who is armed, and you have to give money. If you don't give money, the man doesn't let you go. Isn't that robbery? So the police themselves are committing several millions of robberies every day. Nobody's talking about those small things. Address those small things, and you see the big things will fall in place.
Thank you. I was going to ask about the role of the police. Now that you've touched on it, what can the police specifically do?
Well, I will tell you this. Those who are the helm of the police are the ones who can help. I was reading a story, I don't know whether it's a fiction, of one C.P. Mohammed. I read this in one of the blogs. It says the man who is commissioner of police, he just said on a Saturday he would just drive himself. And he drove himself through Herbert Macaulay. Herbert Macaulay is where you have the Pantee, the police station. And then, of course, he got to the police checkpoint, and the one police sergeant said, "Stop here, my friend. Who owned this car?" And the man says, "I'm the owner of the car." He said, "Tell me, it's your father that owned the car." He says, "No, the car belongs to me. Show me your ID card." And he said, "I won't show you my ID card until you show me your ID card." And the inspector there said, "You have the temerity to question a policeman to show you his ID card anyway. In any event, you're under arrest." So they took him to Pantee police station in Lagos. And what did he do? When he got there, the commissioner of police parked his car where the DPO parks his car. He said, "My friend, you can't park your car there." He says, "This is where I want to park my car." He said, "Then you are really into some soup today." Took him into a room where he's going to be interrogated. And he met a man who is an ASP, or so, an assistant inspector of police. He was wearing short knicker and a T-shirt. He says, "Take his statement." So he was going to be taking the statement. And the man says, "No, I won't let you take my statement because you're not dressed like a policeman." And he says, "You still have the temerity to ask more questions." Then, all of a sudden, a corporal came in and looked at the face of the man and looked at the wall and saw that the picture there on the wall is the commissioner of police. The man dashed through the window. And in a few seconds, all of them had disappeared. That's what it takes to clean up the police. Those who are at the top can come down. So it's like coming down from the horse and looking at the horse right in the eyes to know how the race was. Because if you sit on your high horse, you will not know what is happening. And that's the same problem we have in the judiciary, we have with lawyers. You have judges, chief judges who are there. They don't go to the bailiff room to see what lawyers go through. They don't go to the cash office to see what exactly goes on. They drive into their offices in siren and they walk straight right into their offices and they stay in an air-conditioned office. So when they talk about access to justice, they don't understand because they don't feel it.
Okay, what else can the courts do? And when we talk about alternative dispute resolution methods, do you think that can also help?
Well, you see, first and foremost, before we even talk about alternative dispute resolution, judges need to treat litigants as customers. You know how you treat a customer? A person who has come to purchase a commodity from you. In old England, judges used to earn salary. Part of the salaries judges earn come from the cases they do. And I wrote a paper many years ago. It has to do on law and economics and how it can help to reposition judges. If judges should ask themselves, if I were to be paid salary from those who come to my court, how many litigants would prefer to come to your court? So we just heard of Capio, the man who died in America, because he makes you feel comfortable when you're in his court. So we need to come to see that we're serving people. The judicial arm is an arm of government that should serve the people. So when litigants come, treat them with respect. Even as lawyers, treat the litigants with respect. This is where to start from. When we start from there, you'll find that the courts become a conducive place. When the court is a conducive place, people won't be talking about even the alternative things.
How about when we look at indigent litigation?
For judges to chat litigation in this country. And the Supreme Court it should be a court of policy. But here we have a Supreme Court that is picking and hair splitting. Or a man who has done a case up to the Supreme Court now complains, say, look, I was not personally served in the High Court. And the Supreme Court says, yes. So that makes it a nullity. What's the purpose of service? Service is to ensure that the that Nigerians are smart people. They don't need legal education. They know their rights, but they know that they cannot vindicate their rights. That's the issue. It's a thing to know that you have a right. Then it's another thing to know whether it's to believe in the system. People don't believe in the justice system in this country, and that is why they say the slogan today is you complain, go to courts, because they know that when you are there, the thing just gets unresolved, and people just get tired out. So it's not a question of really education. It's a question of making the rights really real.
How can we do that?
Well, I'm one person who believes that we can ask for your rights, but then do not ask for your rights and lose your lefts. That's one of the things I always tell people. Well, it means in effect that all of us need to go back to the drawing board. Ask ourselves, how can things be much better? I think it's a societal thing, and the lawyers who are supposed to be above the society and showing the way themselves and are just messed up in the society. And the judicial system that should actually be above society is itself inside society. That's not how it should be. That's not how it operates. Because you see, many years ago, even in England, the king had so much powers and nearly absolute powers. But the Lord Chancellor would tell the king, you cannot do this, you cannot do that. But where do we have such judges, or where do we have such lawyers who can tell politicians they cannot do what they're doing? I remember a lawyer told me a story, very sad story, that he was doing an arbitration in England, and he cited a Nigerian case, and the arbitrators asked and said that case was decided what year? And he said 2020 something. He said, no, don't cite those cases for us. Cite a case that was decided before 2000. And so it tells you that Nigeria was held in such high esteem, but today, and the 10 great countries and judiciaries in Africa, Nigeria is not there. When I went to University of Lagos, 1979, University of Lagos Faculty of Law was rated as number 6 in the Commonwealth. That's what we were doing. But I'm not sure the University of Lagos will come into 100 today. So you see that there's so much happening in the country. So lawyers need to up their game. The NBA must do something. The judges must do something. The attorney generals must do something. Even the young lawyers, all of us must come together and say, look, we have a problem. How can we fix this problem?
Okay. The average Nigerian that feels that their rights has been trampled upon, while not trusting the judiciary, what can they do?
Well, it's like saying that you don't trust the thing, but that's the only alternative. Like the police will say, if you think the police is not your friend, then look for a dog to solve your problem. So they really have no choice. That's the only choice they have. So so that's why they will keep complaining. And the complaint is not because they like to complain. They want it to improve. So all we need to do is to improve it.
Okay. Because we are not just talking about the problems, what, reforms can we, as lawyers, as civil society, as judiciary, what reforms, holistic reforms can we make at this time?
One, I do not subscribe to reforms in forms of making new laws. The existing laws should be properly enforced. For example, the Criminal Justice Act provides for prison visitation. Let those things be made. Put teeth to it. Put muzzle to it. Visit the prisons. Visit the detention houses. Visit the police stations. Those who shouldn't be held there should be freed. If we do that, I am sure the police will say, look, if you keep a person here beyond the time he should be kept here, the person will be free. So people will go to police station and say, well, even if they refuse to give me bail, I'll be here for a short time. I know there's going to be a visit.
Here soon.
So once you have that kind of thing, it's good enough. So let us begin to think about how we can enforce the law. Let us also reform, if it is possible, legal education, because our legal education is too elitist. We need to bring people to see exactly what they do. People graduate from the law schools and from the universities. They've never been to a prison. They don't know what people suffer in the prison. They know. So let's public advocacy be part of the curriculum of the universities. Let judges themselves visit prisons, visit police stations and things, and use the law properly. And then I'm sure that because the people feel the character of law more in relation to criminal laws. So let us see how we can make criminal laws work and criminal procedures work. Once they work, the Nigerians will begin to build faith in the judiciary. They will build faith in lawyers. They will build faith in even legal education.
Okay. Will you be suggesting, or should I suggest now, maybe instead of chamber attachments, maybe students should be attached to the correctional facility,
If you
for a few weeks?
If you ask me, I think legal education is too lengthy in Nigeria. What are they learning in 5 years? And then another year in law school, 6 years? I think what they should do is that every student, we can cancel the law school as a program, yes, turning the law school program into the universities, and the law school can be an examination body like it is in America. That's all they do. And then, of course, before you qualify to write the examinations, you must have some public advocacy hours. And if that is made, for example, that you must have 150 hours, so a student from year 1 to year 5 or year 4 has to visit the police station, has to go to prison, has to go to hospitals, let them do some public thing. So once they have those things, with their LLB certificate, it will now qualify them to write the exam. Because the truth about it is that if, like I always say, what we call the big grammar, we call it standpoint epistemology in philosophy. But the common man on the street says experience is the best teacher. If you have not experienced a thing, you hardly can know how it really feels. So if they go to work in police stations, and a law student is attached to a police station for 4 or 5 days, he will see exactly how things happen there. He will feel what the people do feel. So when he now writes this exam and he qualifies as a lawyer, he really understands what it is to go through the problem people go through. I've been in courts where, I tell you one sad story. One of my partners was arrested. I'm sure you know him, Dele Fautimi. And I was doing that case for him, and I was in Ekiti. And while doing that matter, I know what we suffered through. But that's Nigeria for you. So we need to make rights substantive. The man was granted a bail for 50 million, and the person is supposed to have a house in Ado Ekiti. I don't live in Ado Ekiti. My partner doesn't live in Ado Ekiti, and we need a 50 million naira bond. He had to stay in the correctional center, and fortunately, the Afenifere got him out on bail and all that, met the conditions. Why should those conditions be made for bails? And somebody says you're granted bail, one of the person must be a level 16 officer. So we're tying freedom to money. That's not how it should be in any society. These are problems that must be addressed by lawyers and by judges.
Okay, sir. Your final word on this topic, sir.
There's hope for Nigeria. There's hope for the judiciary. There's hope for lawyers. It is not to kill the lawyers, but it's to reform the lawyers, reform the justice system, make Nigeria great the way it used to be.
Thank you. Thank you so much, sir. Thank you, Leonard Silk, for joining us on the show this morning. Thank you for also staying tuned with us. That is our show this morning. Hope you've learned a thing or two. See you next week. Have a great weekend. Thank you. Thank you.